Welcome to the latest edition of PatentYogi News. We have changed our format from weekly news to monthly news. So every month we will publish one video, covering the recent activity in the patent world. President Obama wants to see a bipartisan patent overhaul reach his desk before the end of 2015, and the White House is responding favorably to the new Senate bill, introduced earlier this May. This legislation builds upon the America Invents Act, signed into law by President Obama in 2011. One of the main goals of the legislation is to combat the so-called patent trolls. The measure is the work product of a large group of members of the Senate Judiciary Committee, led by Majority Whip John Cornyn and Senator Charles Schumer. We live in a global economy now. So, as the United States Congress reforms the United States patent system, the rest of the world is watching eagerly. The Congress is trying to limit the ability of plaintiffs to file lawsuits to combat patent trolls. However, foreign governments may see the United States action as an opportunity to limit the ability of plaintiffs in their countries, many from outside their territory, and thus giving an advantage to their domestic industries. Foreign governments already make it difficult for outside companies to prevail in patent matters in their countries. Any limitations to the enforcement of a patent in the United States will be magnified in countries around the globe. Therefore, the Congress needs to assure that the reforms are crafted in a surgical manner to avoid the unintended consequences of preventing a legitimate patent holder from enforcing her rights. This is very important to patent holders in the United States, but also critical to the thousands of innovative U.S. companies that rely on patent protection to sell their products in foreign countries. Meanwhile, both sides of the patent reform debate have been lobbying Hillary Clinton. Hillary Clinton revealed the names of the various companies and trade groups that have collectively given her millions of dollars in speaking fees since 2014. The list included many companies with a strong interest in the patent reform debate. Overall, Clinton was paid speaking fees by about 50 companies and groups. Of those 50 organizations, at least 5 have a record of lobbying against reforms to the patent system, while 3 are in the pro-reform camp. Clinton herself has been silent on patent issues. However, she'll have a lot of influence over patent policy if she wins the White House in 2016. The USPTO recently released the Patent Application Alert Service. Users of the system create an account and then save one or more searches. Whenever a patent application relevant to the search publishes, an email alert is automatically sent to the users. Thereafter, the users may submit prior art for the published applications. The pre-issuance submission of prior art for consideration by a patent examiner was one of the many changes brought about by the America Invents Act. The Patent Office is hopeful that it will be useful with respect to enhancing the quality of patent examination and issued patents. May 13, 2015 marks a significant day for inventors who apply for design patent protection in the United States. On that day, the United States changed rules to implement the Hague Agreement for the registration of industrial designs, which allows applicants to designate over 60 countries with a single design application. The international design registration can be a very cost-effective way of obtaining protection in large number of countries, since it streamlines the application process into a single proceeding. The new structure also extends the term for all U.S. design patents from 14 years to 15 years. Google launched an experimental marketplace called the Patent Purchase Promotion. Google wants to beat non-practicing entities in buying patents from the inventors. Google opened the marketplace portal for patent holders between May 8 and May 22 to submit their patents. Google is now reviewing all the submissions, and by June 26 promises to let patent holders know which patents it wants to buy. Google will then work with patent sellers to close the transaction in short order. In a dramatic shift from recent years, which saw the annual growth of 20 to 30% in patent lawsuits, the number of cases filed in 2014 decreased by almost 13%. This decline in cases is largely a result of the U.S. Supreme Court's decision in Ellis v. CLS Bank case, which raised the bar for software patentees to prove their claimed inventions were patentable subject matter. Ericsson sued Apple in Germany, the UK and the Netherlands, as it ratcheted up a global licensing battle between the companies. Ericsson is seeking a patent licensing agreement for technologies fundamental to the way mobile devices communicate, and for IP related to user interfaces, batteries and operating systems. Apple had been paying royalties to Ericsson before a license expired in mid-January. When talks over renewal failed, the companies sued each other, seeking court rulings on whether Ericsson's royalty demands on fundamental technology were fair and reasonable. The Unitary Patent is coming to Europe. Europe will finally see a single patent for 24 countries, and a single court at European level to enforce the new Unitary Patents. The Unitary Patent will require just one central registration and one annual fee. The Unitary Patent makes the process much more manageable. Also, the value of patent enhances, as it covers a market of 400 million consumers. The new Unified Patent Court will have jurisdiction to handle actions on infringement and validity of the Unitary Patents. The court has the powers to declare a patent invalid for all EU countries, with a one single invalidity action. Last month, John Oliver did a story on patent trolls, but his report was full of errors. So he prepared a reply in his own style. The link to our response is provided in the description below. An 1891 patent resolved the over versus under toilet paper roll debate. The patent clearly illustrates an over arrangement for toilet paper. Google patented a method for self-driving cars to understand a cyclist's hand signals. This makes self-driving cars even more safe. Earlier last month, Google had come under some criticism regarding accidents caused by these cars. Thanks for sharing and liking the video. Please feel free to subscribe to our channel by clicking the big red button below. Until next time, keep innovating and keep patenting.